In this, in this lecture, we would like to discuss another great thinker and a great mind of 17th and 16th and 17th century is Hugo Grotious, a Dutch scholar, jurist, and magistrate, and in his famous celebrated work The Freedom of the Sea and other studies established his fame as a jurist. At the age of 30, he was appointed the magistrate of Rotterdam. He became the chief administrative officer of Westphalian and Holland at the age of 33. In 1625, his greatest work, The Laws of War and Peace, was published, which won him a great fame and made him the father of modern international law. Grotious postulated law as a necessary concomitant of social existence. He thus follows Aristotle in holding that man by nature is a social animal. He holds that man and society are so interlinked that cannot exist without the other. He declares that even the arenas have need of some common regulatory measures. There must be some noble system of law and justice in their common relation. Law, which is an essential, natural corollary of society, is also an outgrowth of reason. Therefore, according to Grotius, whenever there is social life, there is reason, and likewise law, and that is natural law. Grotius defines natural law in these words: the law of nature is a dictate of right reason which points out that an act, according as it is or is not conformity with rational nature, has in it a quality of moral baseness or moral necessity, and that in consequence such an act is either forbidden or enjoyed by the author of nature, and that is God. So, we would like to discuss Grotius' contribution to law of nations. And Grotius was the first jurist to produce a comprehensive and systematic treatise on international law, and therefore he is regarded as the father of international law. Before Grotius, no one had attempted the treatment of the subject in its entirety. Its leading principles were recognized by the international community. The central theme of Grotius was the totality of relations between state as governed by law. He distinguished just wars from the unjust ones and rejected the idea that states have absolute right to make war. The will of the states was not to be the only source of international law. The basis of international law, according to him, is the nature of man, which is endowed with goodness and morality. He rejected the idea of the reason of state. Grotious also propounded the theory of qualified neutrality, by which nations carrying on a just war was to be bound. The law of nations included those practices which the civilized nations follow in the dealings with one another. So Professor Dunning says its content is what has been accepted as obligatory by the consent of all or of many nations. What is included under it is proved by constant usages and the testimony of the learned. The occasions for such a body of rights is welfare of that aggregate, which includes all or many nations, just as the occasion for civil war is the welfare of the aggregate, which consists of many individuals. So Grotious expressed the view that promises and obligations must be fulfilled in good faith. He also finds that fundamental rights and freedoms of individuals should be guaranteed. He was against war and encouraged the settlement of disputes by negotiations with a view to help the cause of international cooperation. He favored the extradition of criminals. As we have already said, Grotious made a distinction between natural law and law of nations. The law of nations is generally based on the consent of the nations. Grotious found that many people of different ages and countries had similar opinion on certain matters. So according to him, this was due to some general cause. As he says, this cause must be either a just deduction from the principles of natural justice or universal consent. The first discovers to us the natural law, and the second, the law of nations. In order to distinguish these two branches of the same science, we must consider not merely the terms which authors have used to define them, but the nature of the subject in question. For if a certain inferred from admitted principles is nevertheless found to be everywhere observed, there is reason to conclude that it derives its origin from positive institutions. The main aim of Grotious seemed to lay down those rules of justice which should be binding on man, and as also to apply those rules under the name of natural law to the mutual relations of separate communities. The view of Grotious was that the rights common to all were derived from natural law. So, in his own words, which is the dictate of right reason, indicating that any act from its agreement or disagreement with the rational nature has in it a more moral necessity. Undoubtedly, Grotious had an abiding influence of the history of international law. So the international jurist, professor, Judge Stark, in his work International Law, expressed that Grotious had an abiding influence of the history of international law. He was continually relied upon as a work of reference and authority in the decisions of courts and in the textbook of later writers of standing. So also, another international jurist and professor, Bradley, in his Law of Nations, puts his views as follows. Few books have won so great a reputation as the De Jure Delicia Passis, but to regard its another as the founder of international is to exaggerate its originality and to do less than justice to the writers who preceded him. Neither Grotius nor any other single writer can properly be said to have founded the very system of international law. So also, in the words of Professor George Sabine, Grotius' importance in the history of jurisprudence rests not upon a theory of the state or upon anything that he had to say about constitutional law, but upon his conception of a law regulating the relations between sovereign states. Grotius' contribution to the special subject of international law is beyond the limits of a history of political theory. In respect to the better, his importance lay in the philosophical principles upon which he sought to found his special subject. Accordingly, assessing the importance of Grotius' works, Professor Jackson wrote, his work has remained a living force. He is no longer read as widely as in past centuries, but the essence of his thought has far passed into the conscience of civilized world. And in relation to that, we would like to discuss Grotius' views on sovereignty. So Grotius draws to a large extent his doctrine of sovereignty from Buddha. However, his doctrine is not as definite and logical as Buddha's. Grotius holds sovereign as a super political power vested in him, whose acts cannot be rendered void by any other human will. Grotius is of the opinion that by nature everyone has a right to resist a wrong, but when civil society has been instituted for the preservation of public tranquility, this right becomes subject to the prescription of the sovereign. Against the sovereign, the right of resistance is null for the reason, among others, that those who instituted civil society deliberately will their rights to the holder of supreme authority. Grotious further says, defining his sovereignty in relation to law of nations, originally meant not by the command of God, but of their own accord, after learning by experience that isolated families could not secure themselves against violence, united civil society, out of which acts sprang governmental power. So, we had to conclude. So, in our conclusion on Hugo Grotius' law of nations and in connection to sovereignty, would like to take the very words of Professor Dunning, who expressed that Grotius' conception of sovereignty falsehood in respect to logical precision and coherence of that of Buddha is self-evident. An authority that is absolute yet bound by pledges, that is at once a unity and divisible, that is complete yet terminable at a fixed time, and that inherent equally in protector and protected, in lord and in vassal, is a confusing king of concept. Besides that, all the above comments and views why Professor and international jurist Professor J.G. Stark and Professor Bell in his Law of Nations, and also Professor George Savins in his work History of Modern Political Theory, so also in the works of Professor Dunning, it is found that no doubt his concept of sovereignty is limited in comparison to the concept of sovereignty provided by Buddha, but his limitations of sovereignty, as we found, is in regards to his theory of law of nations, as because the very exposition of his theory relating to law of nations itself requires the limitation of sovereign power of a state to establish and draw international unity and stability and international peace. That exactly we found after analyzing his great works, that is the laws of war and peace, and also the freedom of the sea. So, at an early age, as he became a jurist, so also became a magistrate and a chief administrative officer. And exactly his two famous works or celebrated works such as the freedom of the sea and the laws of war and peace, in spite of his limited concept of sovereignty, entitled him to as the father of modern international law.